Welcome to True Crime South Africa. I'm Nicole Engelbrecht, and you're listening to a special edition episode. Those who shall not be named. Minor offenders and victims in South Africa. Before I get into today's episode, two quick things. Firstly, episode 200 is going to be recorded live on Zoom on the 21st of February, and you can join in. It's 100 Rand per ticket, and a portion of the proceeds will be donated to a local charity. Patreon members get in free. It's a huge milestone, and I'm really looking forward to sharing it with you. Second thing, don't forget that True Crime South Africa has partnered up with the South African Criminologist platform, and if you head over to their website now, you can stock up on a wide range of true crime-themed merch, including tumblers, stickers, pens, mugs, and so much more. Use the code TCSA at checkouts, and you'll get a site-wide discount of 10%. Check out the full range of true crime-themed merch at sacriminologist.co.za and support TCSA while grabbing some truly cool goodies for you or your partner in crime. Right, so this episode is going to be about something that has been on my mind a lot lately, and something that I think requires clarification, because it's very clear that many members of the public do not know these legislative changes have happened, and I think they are incredibly important to understand for various reasons. To begin to explain these changes, I'm going to use an example. In 2012, a 15-year-old boy murdered his father, mother, and sister on their farm in a town called Griquastad. He was found guilty of these charges, as well as a charge of raping his sister. According to the law at the time, journalists could not name him until he turned 18, even though his identity was quite obvious to everyone because his family members had been named. Everyone knew there was a 15-year-old member of the family and that a 15-year-old person had been arrested. After he turned 18, his name became well known and well publicized. At the time, this was done quite legally. The individual was sentenced to an effective 20 years in prison due to concurrent sentencing, and him being a minor. Over the last few years, including this year, this individual has become eligible for parole. However, you would have noticed a big difference in how journalists were reporting on him. Most articles published in 2025 and 2026 about this parole bid no longer named the offender. I knew why, but many members of the public did not understand it. And I think the vast majority still don't. We know his name. Why aren't we allowed to say it anymore? Also, in the last 2 years, we've seen another case in the headlines which has involved a minor offender. 16-year-old Devonay Nell was murdered by a 17-year-old boy who attended the same school as her. From day one, that offender was not named. And when he turned 18 while still in custody, and even though he has since been found guilty and sentenced, he has still not been named. And again, I saw members of the public not only utterly confused about why this was happening, but also some going out of their way to expose his identity, and then very quickly taking their posts down when they were informed that they were actually contravening the law. So, you may ask, what the heck is happening? Why are we seemingly suddenly not allowed to name minor offenders after they turn 18 anymore? Well, it's not really that sudden. It's a change that's been brewing for a while, and it all started in 2019, when a case was heard in the North Gauteng High Court, in which the Centre for Child Law, or CCL, represented several applicants in a case against most of the major media houses in South Africa. The applicants the CCL were representing included both minor offenders and minor victims of crime. You would absolutely recognize the names because all of their cases were very high profile. And as a result, once they had turned 18, their names became very well known. One of the offenders was the individual I mentioned earlier, who was 15 years old when he committed 3 murders and a rape. Among the victim applicants was a young woman who had been abducted just hours after her birth and had continued to unknowingly live with her abductor until she was in her late teens, when her true identity was uncovered and her entire life fell apart. The CCL was representing the interests of all of these minor parties, and in essence, every minor like them, whose case would occur in the future. While the motivation for the victims and the offenders was slightly different, it all boiled down to the fact that the applicants were saying that having their names attached to these crimes and being so widely publicly known without their consent had negatively impacted their lives to such an extent that psychological damage had been done to them, and it had prevented them from ever being able to live a normal life under their own name. For the applicants who had been offenders, the CCL proposed that by revealing their names to the public, any work that had been done to rehabilitate them and reintegrate them into society could be completely undone. A very important point in the applicant's case was the difference between what is in the public interest versus what is interesting to the public. The public interest is the basis of journalistic reporting. It is the difference between printing gossip about a celebrity affair that's not going to change anyone's life and running a story about someone accused of sexual exploitation, for instance. And the applicants argued that while it may be in the public interest for them to know about a crime, specifically in the case of minor victims, it didn't serve that interest for the public to know the victims' names. The CCL argued that the story could be and had been told with a pseudonym being used, and it would not detract from their reporting at all. Of course, this becomes a more difficult contention when we discuss minor offenders, because it could be argued that the name of a violent offender, regardless of how old they were when the crime occurred, is in the public interest. The applicants also presented 3 expert witnesses who had worked with minor victims, witnesses, and offenders for decades, and spoke to the psychological harms, the impact on witnesses and victims, and the harm experienced by accused and offenders, particularly the impact of identification on their trials and the process of rehabilitation and reintegration. A psychological report presented as evidence drew on real case studies and showed that the identification of minors, regardless of their role in a crime, had impacts which included diminishing chances for rehabilitation and reform, social stigma, reliving of the original offense or trauma, feelings of intimidation and humiliation, and anxiety over possible identification. Essentially, the idea was that if a minor offender is eligible for release into the community, then the Department of Correctional Services should be certain that the offender is no longer a danger to the community, and that the damage experienced by minor offenders when their names are exposed far outweighs any possible benefit of the public knowing their name. Minor offenders, of course, should be the most rehabilitatable of all offenders, if the system, which will include many departments for minors, does its job and ensures that the offender has all the support they need to rehabilitate and reintegrate. Essentially, the CCL argued that by naming minor offenders when they turn 18, you undo any good that has been done and take that individual right back to who and where they were when they committed the crime, thereby increasing the chance that they will reoffend. On the offender applicant side, the court heard evidence from both minor offenders who had been identified in the media and those who had not. The offender I've previously mentioned, as well as another individual who at 15 was involved in the murder of a high-profile political figure, provided testimony about their experiences of being identified at age 18. Both individuals confirmed in their testimony that they had experienced negative effects from being identified and having their pictures circulated by the media, and both said that they felt that when they re-entered society, they would have less chance of reintegration because they would always be wondering who knew what about their past, and employers might be less likely to take them on. While this is certainly very likely true, many might say, well, how is that any different from an adult offender? They too have to experience that. And yes, they do. And it definitely has a negative effect on them too. But I think what the CCL is trying to point out here is that we must, as a society, be able to distinguish between the offender and the child. A child does not stop being a child when they commit a crime. And the CCL's case was that minor offenders, as perhaps the class of offender with the most hope for rehabilitation, must not be demonized by their crime to the extent that we take away their minor status and treat them as adults when they have not been sentenced as adults. And now, if we want to stand by the claim that knowing the identity of these offenders is in the public interest, another two minor offenders who were part of this application throw a spanner in those works. Two individuals identified only as P and X were minors when they were both convicted of serious crimes. P was 12 years old when she was convicted of orchestrating a hit on a family member. By the time she reached adulthood, though, she had long since served her sentence. By the same token, X was 16 years old when she was convicted of acting as an accessory in the murder of family members in which her much older boyfriend had committed the murders, and she had assisted in planning and covering up the crimes. X also served a sentence and was released. Neither individual has ever been identified in the media, and both provided testimony that having their anonymity made a huge difference to their ability to move on with their lives, and both are now educated, working successfully, contributing members of society, and have families of their own. So why were these two individuals never named, and the previous two were? Were these two less in the public interest than the previous two? No. It turns out it was all a matter of timing. You see, in the first two cases referenced, the offenders turned 18 while their cases were very much still in the public eye and very high-profile media stories. The second two cases were long forgotten by the time that happened. So, the CCL argued, if revealing the names of minor offenders is truly in the public interest, then why did the media not hunt down the second two minor offenders and reveal their identities when they turned 18? Perhaps the answer is that those cases were no longer interesting to the public, because they were essentially old news. The second two offenders had agreed to submit their testimony as part of this case because they both said they lived in daily fear that their identities would be revealed. And as they both had children, they were terrified about what impact that might have on them. So that was the applicant's case. And then the respondents, the various media houses, were allowed the opportunity to respond. For the most part, the media's case revolved around three elements: open justice, media freedom, and the public interest. The respondents felt that an overarching ban on the publication of minor offender and victims' names would interfere with their ability to inform the public. The applicants counter-argued that they were not requesting an overarching ban, and a judge would have the right to overrule the anonymity allowance and grant the media the right to publish names if they could show it was truly in the best interests of justice and/or in the public interest. The media respondents also argued that laws were already in place to adequately protect children against harm, and any additional rulings or legislation would unfairly limit their ability to freely cover criminal cases. The applicants responded by saying that it would be unfair to put the responsibility of bringing legal proceedings on the children and their representatives, who would be vulnerable and unlikely to be able to afford such action. And in any case, a ruling in their favour would not undo the harm once it was caused. Media houses, on the other hand, were far more capable of bringing cases should they wish to apply to name minors after they turn 18, and they would have the resources to do so, as they'd proven in the past. The media respondents also argued that, in their view, naming child victims was actually to the victim's benefit. As evidence of this, they presented a case we're quite familiar with here on True Crime South Africa, the Van Breda family murder, which occurred in Stellenbosch. In that case, the offender's minor sister survived the attack, and she was named in the media. The respondents said that the girl had received an outpouring of support from the public, and this proved that their coverage had been beneficial to her. The applicants countered this by submitting testimony from that victim's legal representative, who clearly stated that the victim was most certainly not of the opinion that she had benefited at all from the media releasing her name. On the contrary, after suffering a traumatic brain injury, she felt that her reintegration back into normal life and her healing was severely negatively impacted by the fact that she couldn't go anywhere without someone knowing who she was. The judge would later comment on the extent of the coverage of the victim in that case in their judgment, saying that they could not see how it would have been in the public interest for journalists to write about a teenage girl attending rugby games, for instance. Finally, the media respondents put forth that self-regulation by the media was the best course of action, and there did not need to be any additional legislation in place, and doing so would place an unjustifiable burden on the media. In an academic article I read about this case, the writer proposes that what was truly driving the media's desire to be able to name minor offenders, victims, and witnesses may be profit. To underpin this, the writer quoted from the media's answering affidavit, which read, quote, "Stories of crime committed against anonymous children, to whom the readers cannot establish any emotional connection, will simply not compete for readers' attention." End quote. And of course, it probably goes without saying that readers' attention is the equivalent of profit in this industry. I'll give you a bit more of my own opinion around this whole case a bit later on, but I will say at this point that I too have found the value of emotional connection from listeners when they can meet a victim, so to speak, through my words. But equally, I've covered cases where I have used pseudonyms, and those have not really got any less engagement. I realize my platform is different. I'm not competing on a few 100-word articles with other outlets. I tell the stories of violent crime in their entirety, and usually that's enough to get listeners buy-in. They know that these are real people. Their real names, although important on the whole, are not vital to connecting with the victims and their experiences. But I can imagine that might be different for the mainstream media. The question is, does the profits they need to make to fund their work override a child victim or offender's right to live the remainder of their lives without constant public attention? This case did not have a simple conclusion. When initially heard in the High Court, the judge only granted partial relief to the applicants, but initially refused the so-called adult extension portion of the request. But things didn't stop there. The case then went on to the Supreme Court, and finally the Constitutional Court, where the matter was finally settled, with the court declaring that Section 154(3) of the Criminal Procedure Act was constitutionally invalid to the extent that protection does not extend beyond children reaching age 18. The declaration was suspended for 24 months to give Parliament time to remedy the constitutional defect. In other words, at that time, the courts recognised that child victims, witnesses and offenders needed protection, and they ultimately left it to Parliament to determine how to extend that protection beyond age 18, rather than the courts imposing such an extension themselves. In February 2022, Parliament successfully enacted the Criminal Procedure Amendment Act 16 of 2021, which meant that child victims of crimes, not just accused and witnesses, now had their identity explicitly protected, and most importantly for our purposes here, that protection extends past their 18th birthday, and essentially for the rest of their natural lives, unless a court explicitly rules otherwise on an individual case brought before them. And so that is the behind-the-scenes journey that has led us to where we are today. And if you've noticed these small changes happening along the way in media coverage and access to certain episodes of television series, you may now better understand what was behind that. You may have, for instance, noticed that there was a time when certain television series had archived episodes related to minor victims and offenders, and those stayed archived for quite some time. And then we started seeing those news articles that referred to offenders whose names we knew, but didn't actually name them. Hopefully now, it all makes sense. I started hearing about these changes quite some time ago, and was unsure about how it would affect the podcast. While the exact changes are quite clear, when it comes to a creator who's been making content since 2019, there were still some things I was unsure about. And while I could guess and hope for the best, that's not the most responsible thing to do. So I consulted a very experienced media lawyer. Now, the lawyer confirmed what I suspected as I read through the basis of this case. And that is that these legislative changes have been made on some pretty shaky ground. That's not to say they'll be reversed, but they are very easily challenged if you have enough money to do so in court. There will undoubtedly be cases in the future that will set precedents around which different decisions could be made. But I don't personally want to be setting any of those legal precedents. So I'd prefer to operate on the right side of the legislation as it stands. I want to start out by reading to you the section of the Act that pertains here, Section 154(3) of the Criminal Procedure Act, and specifically subsection 3. Quote, "No person shall before, during, or at any stage after the conclusion of criminal proceedings in any manner, including on any social media or electronic platform, publish any information which reveals or may reveal the identity of an accused who is or was under the age of 18 at the time of the alleged commission of an offence, a witness who is or was under the age of 18 at the time of the alleged commission of an offence, or a person against whom an offence has allegedly been committed who is or was under the age of 18 years at the time of the alleged commission of the offence, unless the publication of such information is authorised in terms of subsection 3b. End quote. In plain terms, this means we cannot publish the identity of any under 18s who are accused, witnesses, or victims at any stage before, during, or after criminal proceedings, absent an order of a court, even if they have since become adults. And when I say we, I mean every single South African, not just journalists or podcasters. This applies to everyone. My main question at this point was, okay, that's all good and well. From the 9th of February 2022, this is what we should have been adhering to. But what about articles and other forms of publication that happened prior to that date? Arguably, every single piece of content out there that identifies a minor offender, victim, or witness should then either be removed or anonymized, right? Well, yes, if you want to, but also no. The lawyer advised me that the operative word in the legislation is publish. So, because I hit publish prior to the 9th of February 2022 on something, it should arguably be safe. However, and this is a big however, it is also best not to draw attention or refer consumers back to the content that was created prior to that date. And at this point, I'd just like to say that this is legal counsel that I have received that I am telling you about. This is not legal counsel that you will be able to rely on in a court of law. And if you find yourself in any relevant situation, I highly recommend you get your own direct legal counsel around the matter. So as an example, for me, maybe in 2019, I released an episode about a minor offender, and I named them because they turned 18 by the time I released that episode. Although I could anonymize that episode or remove it completely if I wanted to, I don't necessarily have to. But what I definitely should not do is then start to republish or advertise that episode to listeners now in 2026. What would be an example of that for the ordinary citizen who's not a content creator but may talk about things like this on social media, for instance? Let's say around the time prior to 2022 that a case with a minor in it happened. And after that individual turned 18, you mentioned them somewhere on your social media. You do not necessarily need to go back and delete that specific post. But if that post comes up in your Facebook memories, for instance, you definitely should not then reshare it now in 2026. But of course, any piece of material around this topic created by a content creator or by an individual person post 9 February 2022 must be anonymized to protect any minor victims, witnesses, or offenders. I think it's also important to point out that all of this doesn't just apply on social media. It applies to all digital platforms. So WhatsApp, Telegram, and Signal groups are also included. And if you're an admin of a social media group or a messaging group, it is your responsibility to ensure that you are not allowing anything that contravenes this law to appear in your group. The lawyer I consulted also pointed out something else to me which is currently quite up in the air. The wording of the amendment actually doesn't allow for even the minor or the previously minor individual to identify themselves. So, as the law now stands, even if a victim, witness, or offender who was a minor at the time of the crime decides a decade after the fact, when they're already an adult, that they want to identify themselves and tell their own story, they actually have to apply to the courts to do so first. What this means for me and other content creators is that technically, even if someone came to me and said, I want to tell my story on your podcast, but it happened when I was a child. Even if they wanted to name themselves, I would have to anonymize them or not tell the story at all. What this means for the ordinary social media user is that if you fall into any of these minor groups and you decide you want to tell your story in just a post on social media, if you're using an account that identifies you, you technically, as it currently stands, have to apply to the courts to do so first. Obviously, when it's the person themselves doing it, it's highly unlikely that anyone is going to bring charges against you, because it's only your own anonymity you're releasing. But if that decision were to bring harm of some kind to anyone else as a result of you doing that, you could find yourself in hot water. Up until now, we've been talking about solved cases, right? Crimes where an offender has been convicted and the crime against a victim has been cemented in charges. But I wondered, what about unsolved cases involving surviving child victims? What about missing children? Should we not be naming them either? Although we don't technically know that a crime has been committed against them until they're found, it is actually a crime for a child to not be in the care of their legally appointed guardians. So, by virtue of the fact that the child is missing, a crime has been committed to an extent. We just don't know the nature of the crime. So if we aren't allowed to name child victims of crimes, how do we look for missing children? And if we agree that the police releasing the identity of a missing child then allows the public to share that child's identity, what happens when the child is found? Do we then go back to not naming them? I asked the lawyer I consulted this and pictured them muttering under their breath at me as they read their email. They actually did answer very kindly though, and agreed that this was another example of how the amendment was not nearly clear enough, and if followed to the T, not only created a situation of absurdity where we would be sharing blank missing person posters with just a description on, but also we would probably have to not name them when they're found alive. The lawyer advised that they would ordinarily tell their clients to err on the side of caution and not identify the children or their family members in abduction cases. Section 153A of the Act deals with this kind of situation because it authorizes the police to publish the identity of the child in order to locate them. But as the lawyer pointed out to me, it also seems to infer that only the police have the right to publish the child's identity, and only if it's in order to locate the child. Again, if we take the Act in a literal interpretation, that right is still not passed on to journalists or members of the public. But the lawyer agrees that this would be a ridiculous situation. The important thing is for the child to be found, and sharing should happen at least until they are. I will say, however, that it is absolutely vital to still be extremely cautious around sharing images and names of allegedly missing children. I do not recommend sharing posters that don't have a police case number on them, as it is that case number that essentially grants the right to share the child's image in order to find them. And really, this is not a wholly ridiculous situation. After all, one of the main applicants to the original case was in fact someone who was missing for almost their entire childhood, and then they were found. At the time, there would have been missing person posters with their name on it circulated. And then they were found alive. Although it's probably a slightly different slant to a missing persons case because the story got so much notoriety, which was the very reason she brought the case. But it does make me wonder. The Jocelyn Smith case, for instance. Her name has become so widely known, and currently that's a good thing because we want to find her. But what if she is found and she's alive? How will that level of notoriety impact the rest of her life? She would not be able to go anywhere without people recognizing her name and probably her face. I guess that would be a good problem to have to address one day, because at least then she would be home and she would be safe. Of course, it's not just the actual names of the victims and the offenders we have to worry about. It's also any information that could easily reveal their identity. Like, for instance, the identity of their parents. You cannot think you're going to get around this amendment by saying the 15-year-old son of the 2 adult victims and then naming the adult victims, because clearly that creates an identifier. And the same applies to minor victims and naming their parents or siblings. In addition, when an offender is an adult and also the parents or grandparents of the minor victim, then you cannot name the offender either, because doing so would identify the victim. I was doing one of my true crime writing masterclasses the other day, and I was discussing these amendments. And when I got to this example, someone mentioned that they had seen a case recently where a grandfather had been convicted of raping his 2 granddaughters. And there had been a big uproar in the community when the offender was not named. And she hadn't understood until that moment why that was. It wasn't about protecting the offender. It was about protecting the victims. And I see that a lot too, especially in sex crime cases. The public are baying for blood and wanting to know the identity of the perpetrator. But if identifying them also identifies the victims who are alive, they cannot be named. And doing so is most definitely not some heroic act of vigilantism. It is causing direct additional harm to the innocent victims. To wrap up this portion, I do just want to underpin that all of this only applies to living offenders, victims, and witnesses. It is anonymity for the rest of their natural lives, and that right ends with death. So if a victim is murdered, as long as there are no other minor surviving victims which could be identified by naming the deceased victim, they can be named. And if a minor offender passes away, they too can be named, again, as long as doing so does not identify any surviving minor offender or victim. Right. So now we know what we can and can't do in these situations. How do I, as a content creator in this genre, feel about this amendment? Well, obviously it's going to make things a lot more difficult for me and others like me. But that comes with the territory. I produce content about crime, and I hope that my work in some small way contributes to a safer South Africa. And as such, I must follow the law in my content creation. There is no other way. If I come onto this podcast and say crime is bad, I can't then also pick and choose which laws I think are fair and which aren't. I must follow them. Full stop. That's how I see it anyway. In addition to that, there is no question that I will do anything I can to not cause further harm to victims, and especially surviving minor victims and witnesses of crime. So for me, that's a no-brainer. Where a lot of people are having trouble, and where I'll admit I've had some hesitation too, is with the extension into adulthood of anonymity for the offenders. I am going to comply, don't get me wrong, and I believe everyone else should too. But I have had moments where I wonder about the wisdom of it all. I absolutely can see how having something that you did as a child following you into adulthood when you've served your time and you've been rehabilitated could be incredibly damaging and unfair. We have a restorative justice system for a reason, because we believe that the vast majority of offenders can be rehabilitated if given the resources they need. And that, for me, is where the key rests. The only thing that really bugs me about all of this is that we don't know for sure that these minor offenders are actually getting the resources they need to rehabilitate themselves. A case in point is the one I mentioned earlier, where a 17-year-old boy murdered a 16-year-old girl, and their school had no idea that this individual had previously been involved in a rape case when he was 13. And sure, that may not have made any difference. But the enormous problem was that this individual had not received any treatment or follow-up guidance after he was found not criminally liable because of his age. No one knew his name because he was a minor, and seemingly no one was following up to ensure that he had the support he needed to not reoffend. And now, unless this amendment changes, his name will never be known. He has been sentenced to 25 years in prison, but he'll be eligible for parole in 12.5 years, and we still won't know his name. And we can't change that, because it's the law. But what we can do is ensure we now hold the departments involved in rehabilitation accountable for doing their jobs properly. Because now, more than ever, the rehabilitation of especially violent minor offenders is absolutely vital. And yes, there are 1,000 what-ifs here. I'm talking about a worst-case scenario. But for the deceased victim, her worst-case scenario became a reality. There is another way to look at it, though. If we support this amendment and go on the premise that by not identifying minor offenders, we actually give them the very best chance at rehabilitation, maybe, in that way, we could be saving future victims. If a minor offender does not slip back into the darkest parts of them because they are constantly demonized after serving their time, maybe we can actually play a role in them not reoffending. Whichever way you want to look at it, this is now the law, and you and I have to follow it. So over the next few weeks, I'll be embarking on a pretty big project of bringing all the True Crime South Africa spaces into compliance with this law. I'm still deciding what I'm going to do with the episodes prior to 2022, but you will start to see the episodes post the amendment date being archived and then either re-uploaded after being anonymized or in some cases not being republished at all, if it's not possible to fully anonymize. This will happen on all social media platforms too. It's going to be a process, but I'll certainly get it done as quickly as I can. I put together this episode because I think education is one of the most powerful things I can use this platform for. And I'd really appreciate it if you shared this episode with others so they too can understand what changes have been made in the law and what their responsibilities are. At some point, I'll also put together some infographics that can easily be shared on social media and WhatsApp to help spread the word. If you haven't already, this is your reminder to book your ticket for the live recording of episode 200, which will be happening on the 21st of February. Go to the Quicket platform and search True Crime South Africa, and you'll find the event listed there. It's just 100 Rand to be part of it, and if you're a Patreon member, you get in free. Check out the Patreon platform for information on how to claim your complimentary ticket.